But anyway, the sponsor, this is significant. The sponsor of the anti-wiretapping law is Lorenzo Taniaga. You know, the leader of the human rights movement in the Philippines during the anti-Marcos years. So we must see, therefore, the flavor of the anti-wiretapping law as a human rights law. It was meant to protect the rights of individuals against intrusion by the state. And this is further preserved by the exclusionary principle, that if you violate any of these rules, the evidence shall be inadmissible for any purpose in any proceeding. This is a post-Marcos formulation, which makes it all encompassing. The next one. And the Supreme Court also has rulemaking powers. The entire body of law that students will recognize as remedial law is actually not acts of Congress, but issuances by the Supreme Court. And by virtue of that rule, the court has adopted the writ of habeas data to enable citizens to ask a court to step in and order the erasure of data that you feel will violate your right to privacy. And the next one, just to show you, the bottom of this slide shows that part of the relief you can ask for is either the updating, rectification, suppression, or destruction of the database. Well, it's a bit too much. The database or information kept by the respondent. I will now give you an American case. This is City of Ontario versus Guam. The next one, please. Yes. And let me summarize the facts briefly. And I just have, okay. I'll finish in about, begging if I finish in by 11:30, is that? Okay, fine. This was a policeman. The police station issued cell phones on their own budget to all the policemen. And then, in the course, their budget office said, after a few months, they said, hey, our budget is getting too big for the free cell phones we have issued to all our staff. Can we review the records? So they got all the, like the postpaid billings. And they noticed one member of their crew had so many phone calls to one number, so they opened the information available from that. For some reason, they were able to read all the text messages, and it turns out it was private messages to his mistress. So he went all the way to the U.S. Supreme Court, the City of Ontario in California, saying, you know, this is my right to privacy. Well, there is a preliminary issue here. It wasn't, he didn't own the phone, he did not own the account, it was owned by his office. And the rule is that the office can open it. So, for instance, all email messages on an office email is technically owned by the office. But that is not what I'm interested in. It is this. The office said that we found the information in the course of a routine check for purely budgetary purposes. In other words, they did not single out the person because he was suspected of doing some hanky-panky on the side, not suspected of consorting in a mafia. No, they just wanted to find out. We're spending too much. And the conclusion of the court was that if the prohibition is against unreasonable searches and seizures, in this context, it was a reasonable search. In other words, sure, it was a search, but it was reasonable. Compare that to your call data record. The call data record is, by that standard, a reasonable search. In other words, they are not looking, they are not out to look for any specific information. It is data record that they collect purely for the purpose of billing. I will go back to that again in a while. The next law, please, is the Human Security Act. This is the Philippine version of the anti-terror law, and it contains, let's proceed to the next slide, an express exception to the anti-wiretapping law, which says that whatever else that law says, we will be able to intercept and and bug any communication by any terrorist organization for as long as an organization has been judicially declared and outlawed as a terrorist group. Okay. I will now proceed to the single most important slide for students who are preparing for a final exam. The next one. These are techniques to reconcile the competing values. And I will deal with them later. How much privacy is at stake? And the way to lower the threshold of privacy is either to say it is not private, it is public, that there is a lower expectation, or that there was actually an implied waiver. I have some slides for this. The second is to ask who may invoke the right. Can it be invoked by strangers? Can it be invoked by non-parties to the conversation? And who has the burden of invoking exclusion? Who has the burden of showing, of demonstrating non-compliance? Or is it showing compliance? In other words, how do you shift the burden back and forth? And the last is, who is bound to respect the right? How strictly do you apply the state action requirement? And especially considering that we don't get to apply it at all to what is called ephemeral electronic communication, that is in your e-commerce law and the Supreme Court's rules on electronic evidence. So, before I proceed to the specific techniques, I just want to compare that to the EU standards. Detlef has mentioned a directive by the EU. Although, Detlef, I hope you can explain to us later. This is a directive by the European Union at its level. It is implemented locally by each state, and each state would have differential standards. Like the German courts have struck down one implementing law, the British courts have upheld the implementing law. All I could get about from the German case was some poor translation, so you'd have to help us out on that. The first is, the rules are reserved for serious crimes. The first thing I noticed. But the second will show you, in fact, the fundamental normative constraints. It is seen, the constraint is human rights. And this is a test that we'll encounter even in Philippine law. This is the same formulation. When you read this rule, what is important is not exactly the words I put in red, necessity and proportionality, etc. It is actually the means-purpose test. That is how we call it in the Philippines, the minimum test of rationality for police power measures. Meaning, you get the purpose of the law, you get the means chosen, and you try the match, the fit. And here the formula is thus given, must meet the requirements of necessity and proportionality, and therefore must serve specified, explicit, and legitimate purposes, and must be exercised in a manner that is adequate, relevant, and not excessive in relation to the purpose of interference. That is the key formula. And we proceed to the next. The formula is thus carried out. The directive applies only to what we will in the Philippines call the call data record, and not to the content. Well, they also call data record as traffic and location data, and again, not to the content. And that is affirmed in other rules. I will now compare that to what we have in the Philippines. And again, we have guests here from the European Union. Please tell me if our rules deviate from your standards too far. The first is this. We have a clause on information of matters of public concern. And in other words, we have constitutionalized a lower standard of privacy for information that we consider the legitimate scope of public debate. We have in fact a Philippine Supreme Court decision. It's not here.